What three things do not go together? Currently, the Trump administration, the Constitution, and legal precedent. Because the Trump administration is literally blazing through precedent and trying to set its own path and essentially affecting a lot of our rights that we've taken for granted for so long and that are in the Constitution. So habeas corpus has only been suspended 4 times. The first time was the Civil War under President Lincoln. He suspended habeas corpus early in the war, notably in Maryland and along the railroads to Washington, to arrest Confederate sympathizers. And Chief Justice Roger Taney was sitting as a circuit court judge in Ex parte Maryland. Actually ruled in 1861 that only Congress can suspend habeas corpus, not the president. The Habeas Corpus Suspension Act in March 1863 explicitly authorized Lincoln to suspend the writ of habeas corpus for the duration of the rebellion because we were actually under invasion. This isn't similar to the current times where they're trying to say that immigration is an invasion. It is not. That hasn't been found under the law. Lincoln had initially acted under his Emergency War Act power. After 1863, he continued suspending habeas corpus, and Ex parte Milligan, which came out in 1866, later held that even when habeas was suspended, the writ still issued, so the court could determine if the detainee fell under that suspension. The second time was Reconstruction. Remember when they were rebuilding the South in 1871? Congress suspended habeas corpus briefly in parts of South Carolina by the Rights Act, often called the Ku Klux Klan Act, which empowered federal forces against Klan violence. This act authorized suspension in 9 South Carolina counties in order to quell insurrection and protect rights. And then overseas and territories. The Suspension Act was also used in U.S. territories in 1905 during an insurrection in the Philippines, then a U.S. territory. Congress had authorized the suspension of corpus, which carried out to detain rebels. After the 1941 Pearl Harbor attack, it also suspended in the territory of Hawaii. Under the Organic Act, a suspension later invalid by Supreme Court in Duncan v. Kaminsky in 1946, as beyond Congress's authority. These 4 episodes that I just mentioned are the only historical precedent for that, and they are in times of invasion. Also, there are international examples. A lot of nations allow emergency suspension of legal rights, including habeas corpus equivalents. For example, British Parliament actually passed a habeas corpus suspension in 1794 during wartime. Modern human rights law, for example, Article 4 of the ICCPR, permits limited declaration and declared emergencies. But experts caution that suspending habeas corpus leaves people potentially without remedy or the ability to actually question why they're being held. So the constitutional authority calls for habeas corpus. It is explicitly in Article 1, Section 9. The privilege of the writ of habeas corpus shall not, which is very strong language, be suspended unless in cases of rebellion or invasion, the public safety may require it. Because ultimately, once you put someone, detain them, they have to have a remedy to be able to get out of that. And the suspension clause is generally interpreted as a limitation on government, not a free grant of power. It implies that suspension is only allowed or permitted under extraordinary circumstances. And clearly, immigration issues can be settled legally by drafting laws. Not executive orders. Executive orders don't have the power of the Constitution. They don't override the Constitution. I know President Trump is a huge fan of executive orders, but just because he likes them doesn't mean that they carry more weight than our Constitution. Early court assumed Congress had the power to suspend, but nowhere does the Constitution give that power to them or vest that power to them. which is why Lincoln's 1861 suspension prompted Taney's ruling that only Congress can suspend the writ of habeas corpus. The U.S. Constitution in Article 1, Section 9 states habeas corpus shall not, strong language, be suspended unless in cases of rebellion or invasion the public may require it. Federal courts have reinforced the writ's importance in Ex parte Milligan. They emphasized that suspension removes only the privilege of habeas, not the writ itself. The courts still will use the writ to determine if the person is covered by the suspension, if they meet the requirements. More recently, the court has said the suspension clause protects the writ as it existed in 1789. It is a fundamental check on executive detention, meaning a point of checks and balances in which each branch is an equal partner to the other. The legislative branch, the executive branch, and the judicial branch. Not one is greater than the other, although President Trump may differ with that opinion. Also, in immigration and national security cases, there's been a case on that. It was NIS versus St. Cyr Rumsfeld, Boumediene versus Bush. The court has repeatedly recognized detainees' habeas corpus rights. Anyone remember Guantanamo Bay around 2001, 2002? That is what they are talking about. Even non-citizens held at Guantanamo were granted access to federal courts. In Bernardine, 2008. These cases underlie that habeas corpus remains the most efficient safeguard of liberty. And you might say, well, I'm not a terrorist. I'm not doing bad things. Why do I care about this? You care about this because taking away one person's rights, whether they are guilty or not guilty, is a danger to all of us. That's what the Constitution does. It protects rights that are given to us by our country. And that attempts to curtail them will lead to strict scrutiny, which is the strongest hurdle to overcome when trying to get rid of something. Importantly, virtually all experts agree that only Congress can lawfully suspend habeas, not the president, not Stephen Miller. Even Judge Amy Coney Barrett has noted that while the Constitution is silent on who suspends habeas, every historical suspension in U.S. law has been an act of Congress. That should tell you something. In sum, any suspension must meet the narrow, very hard to get, constitutional criteria, rebellion, invasion, and be authorized by Congress. So we've heard Trump's recent statements and proposals. In May 2025, Trump administration officials publicly broached suspending habeas corpus for immigrants. We would be remiss if we didn't mention that clearly immigrants are becoming the punching bag currently in the hot button issue. But how soon before if he were to get it for immigrants, would he start doing it for even citizens? Just goes further and further and further and further. White House Chief Deputy of Staff Stephen Miller and the administration are actively looking at trying to suspend writ for migrants, arguing that the Constitution allows suspension in time of invasion. Immigrants are not a time of invasion. There's already been case law on that. There's a precedent on that. It's been answered. Miller explicitly tied the idea to immigration. He described undocumented border crossings as an invasion and said executives had previously invoked the 1798 Enemies Act to deport migrants. That was actually overturned, and I believe that the Supreme Court also said that they are not in favor of doing that and have since stopped that. Miller's comments were reported on May 9, 2025 by multiple outlets. All quoted him as saying the Constitution is clear. You're right, it's actually clear, but it's not clear on his side. There's been a lot of mistruths, a lot of misconstruction, a lot of issues that are being said that are one way that are actually not. And they wanted a suspension as part of a new aggressive immigration plan. ABC noted that this would dramatically curtail the constitutional right to due process, which is already being affected with the Abrego Garcia case. No official suspension order has been issued, and Miller's remarks indicate a policy proposal or option being explored. Some other Trump-aligned figures have rejected such ideas. For example, former advisor Sebastian Gorka and certain hard right media personalities from Fox and such have expressed that his statement would violate habeas corpus. And so this could potentially have ranging for, if he's going to do it to migrants who he considers enemies and all this other stuff and invaders, political enemies, where's the rest of it going to go? Trump himself had labeled migrants an invasion in rallies in 2024, invoking emergency powers, and in March 2024 tried to use the Alien Enemies Act, in which his aides now suggest habeas corpus might be suspended if courts continue to block his immigration policies. This is not the purpose of habeas corpus. The court is an equal partner in our government with the legislative and the executive. It's not whether or not he wins a case or loses a case. This is about our country and its stability. No formal legislation or executive order has yet to be enacted to suspend this. But the announcement generated widespread scrutiny. A lot of people are concerned about that. Observer noted that any such move must come from Congress. As AP explained in U.S. history, habeas was always suspended with congressional authorization. Something that could be nearly impossible today, given the fractured state of our country and the fact that no party has clear majority, because it's near, and the divided government. Legal scholars immediately warned that the president's unilateral suspension would be unlawful. Similar concerns were raised on Fox News and among Republican lawyers, stressing that judicial review of detention cannot be so easily negated. It is a due process right. And again, he's trying to trample on due process rights again and do what he wants. He has already said he's not a lawyer. We all know that. Thus, the policy proposal seems confined to rhetoric so far, as it marks a sharp escalation in talk of emergency powers within recent U.S. policy. Legal and political implications include civil liberties, because suspending habeas corpus would be taking away civil liberties and have a profound effect on individual rights. Habeas corpus is the principal remedy for anyone detained without charge. Without it, they cannot challenge why they're being detained or the legality of their detention in federal court. In practice, suspension would allow the government to essentially hold people indefinitely without judicial review. Historical memory of Lincoln's suspension, which led to thousands of civilians being jailed without trial, underlies the concern. Legal analysts stress that the suspension clause exists to protect liberty in emergencies. The National Constitution Center notes that the writ has served as a means of reviewing the legality of every detention, a court protection only meaningful when the courts can hear habeas corpus petition rights. Rights advocates warn that stripping habeas could gut due process, enable arbitrary detentions, especially against political enemies or such, or deportations with no court oversight, as has been done previously. As The Guardian summarized, suspending habeas would dramatically escalate efforts to bypass the rule of law, leaving accused individuals without a chance to be heard. And we already talked about balance of powers. A unilateral suspension would upset the Constitution's separation of powers. Article 1 places the writ in the section on Congress's limitations, implying Congress must act. We've heard that multiple times. President attempted this on his own. It would usurp legislative authority and violate the Supreme Court interpretation of habeas jurisprudence. As Steve Medek notes, Miller's suggestion essentially invites an illegal executive decree, not the judicial rule itself, that is imperiling national security. It's the possibility that the government might lose in court, and this is not a substantial reason or even an emergency. So essentially, if judges give him an unwelcome ruling, then he wants to use habeas so that he can pretty much silence them and silence others' rights. The political fallout would also be significant. Congress, civil liberties groups, and many judges have already balked at this idea. Past suspensions were always limited wartime measures, nothing to do with immigration. This is a stark shift toward authoritarian governance in the eyes of many commentators, and I would agree with that. So if habeas were suspended, detainees' only remedies would be whatever processes the executive is willing to give them. Existing immigration proceedings, administrative, as before the DHS or the Board of Immigration Appeals, offer far less protection than federal measures. The Supreme Court has already ruled that those alternatives are not an adequate substitute in wartime context. Constitutional checks on executive detention would be largely dormant in suspensions. So essentially, there would be no legal recourse. Historical and rule of law concerns, broadly suspending habeas corpus reflects a severe curtailment of civil rights, akin to measures taken in civil war or martial law, which we have none. It's a fundamental safeguard that is being taken away if they decide to do that. Also balanced with security. Massive illegal immigration flow as a national security invasion justifying emergency measures. I would disagree with that. But courts have repeatedly rejected such sweeping claims. For example, a federal judge in 2025 refused to find an invasion sufficient to bypass legal process, and Congress shows no appetite to formalize a broad suspension of habeas corpus. As constitutional experts emphasize, the suspension clause is expressly conditional, rebellion, invasion only, not immigration. So again, as I said earlier in the video, do you think that Donald Trump and the Constitution and legal precedent are at odds with each other, or do you think they're congruent? If you found value in the video, please like and subscribe. Have a great day. Bye-bye.